Even as the news has come this year that the DOJ is allegedly making it easier for nonviolent felons to petition to have their gun rights back, though something being a right implies no one should be able to take it away because that instead makes it a privilege, courts are also upholding decisions that the government can ban nonviolent felons from gun ownership for life. As far as history and tradition, the courts pointed to old laws banning Black people, Catholics, and Native Americans from owning guns as the rule's historical analogs. And just to make it a little bit more interesting, all this is against a former Tea Party organizer. Hello everyone, and welcome back to the channel. A federal court has ruled that the government can permanently disarm someone for previous non-violent felony convictions, in this case, financial crimes. Now, of course, if someone is committing crimes and conspiring to steal millions of dollars, they are not a star defendant. In this case, the defendant, Salem Zherka, is a former state Tea Party organizer, strip club owner, and real estate developer who apparently is a big deal on social media, also selling dating courses. He also used to have a newspaper that was critical of the federal government. I have some empathy for Zherka for the part of his case where he tried to reduce his tax liabilities by overclaiming depreciation and underreporting his capital gains because taxation is theft. But Zherka also, between 2005 and 2008, attempted to lie about the prices of apartment complexes he and his friends were buying, as well as the down payments, in order to receive millions of dollars in fraudulent loans, at least according to the feds. He was indicted on charges of submitting false loan applications, tax fraud, wire fraud, and witness tampering in New York. According to the indictment, he received a total of $146 million from 3 banks over 3 years for the purchase or refinancing of apartment buildings in New England, New York, New Jersey, and Tennessee. He faced a maximum of 50 years in prison and millions of dollars in fines. But in the end, he pled guilty to one single count of conspiracy and was sentenced to 37 months in prison, was ordered to forfeit $5 million and pay a $1.5 million fine. Not bad considering what he was facing. He was sentenced in 2015, completed his prison sentence in 2017 as he'd already been in custody for a year at his sentencing, and his supervised release ended in 2020. Later that year, he sued the Attorney General to get his gun rights back. He argued that the federal felon in possession ban is unconstitutional when it comes to nonviolent felons, and I tend to agree with him. I have said it many times on this channel. If someone is considered safe enough to be on the streets and served their time, then that means they should be safe enough to be trusted with their rights, even if I don't agree with the behavior that got them there in the first place. If they can't be trusted with a firearm and are considered that dangerous, then they shouldn't be out, because in the case of many violent criminals, like how many murderers are released and suddenly going to become upstanding citizens? Probably not a large percentage. The government, however, has a totally different view. But before I get into that view, I would like to thank a friend to this channel, and that is Ammo Squared. Ammo Squared helps you stay stocked up on ammo automatically with a set it and forget it approach that helps you avoid shortages and make sure that you have ammo when you want it. You pick your calibers, your monthly budget, and how often you want it shipped, spending as much or as little as you want. Everything about it is fully customizable with no membership dues and no hidden fees. All ammo is factory new from brands that you trust and stored in a climate-controlled environment until you are ready to have it shipped to your door. I have used it myself, and I can say that there are over 70 calibers to choose from and no minimum to buy. All orders are shipped out in 1 to 2 business days, and all orders of $250 or more are shipped completely free. So thank you again to Ammo Squared for being a friend to this channel and just existing in general. Back to our story. I will point out here that in the original court papers, the feds painted Zherka as a violent thug with ties to the Albanian mob. But that being said, they did not bring a single charge against him relating to violence, despite claiming that he'd once found a dead guy in a club basement and another time pulled a shotgun on his daughter's new boyfriend, telling the guy to stop dating her and leave her alone. But he was not charged with anything for those alleged incidents, and because he wasn't charged and wasn't indicted with anything there, we can't take any of that as statement of fact. And as such, that means that the government did not find him to be violent. So, Zherka pointed out that the government hadn't found him dangerous, at least in this, physical violence sense, and so he should be able to retain his rights. A district court dismissed his case in 2022, but the Second Circuit agreed to hear his appeal. And at first, for the first part, they agreed with him. The panel found that Zherka is indeed part of the people covered under the Second Amendment. Moreover, a decision that Zherka does not belong to the people and therefore does not have Second Amendment rights would be at odds with Heller. The court in that case defined the people broadly to include all Americans. It elaborated that the people, as referred to throughout the Constitution, unambiguously refers to all members of the political community, not an unspecified subset. The government does not assert that Zherka is not an American, nor that he does not, as a felon who has completed his sentence, belong to the political community. The court pointed out that one does not, for example, lose their right to peacefully assemble or freedom of speech, to be free of unreasonable searches and seizures, or other rights as a nonviolent felon, and thus excluding them from the Second Amendment would be inconsistent with the Constitution. The Supreme Court's broad definition of the people in Heller, moreover, betrays no intent to carve certain classes from the people only in the context of the Second Amendment. We will neither jeopardize the scope of other rights nor demean the status of Second Amendment rights by narrowly circumscribing the classes of Americans to whom those rights belong. Therefore, they said, Zherka is part of the people. But when it came to the second part of the Bruin test, that's where things got messy. Turning to historical analogs, the opinion states, English, American colonial, and early American histories abound with examples of laws demonstrating that legislatures had broad authority to regulate firearms, including by disarming large classes of people based on their status alone. Religious minorities, political dissenters, Native Americans, and persons of color were among the disfavored groups that historical legislatures disarmed based on a perception that persons in those categories were inherently dangerous or non-law-abiding. Many of those laws are offensive to contemporary moral sensitivities or might well be deemed unconstitutional today on First and 14th Amendment grounds. They are, however, relevant to the Second Amendment historical analysis that Bruin requires we conduct. It's kind of crazy because one of the judges on the panel was appointed by Jimmy Carter and another by Obama. So it makes sense that they might not rule in the favor of gun rights in general, but to cite past discriminatory laws as a reason to uphold this current one is, well, it follows in the vein of gun control being racist and classist, but doesn't follow the current social justice, political correctness du jour. They even acknowledge that those laws might be unconstitutional today, but say that they're still good enough to uphold another unconstitutional law, which seems deliberately obtuse. The status-based disarmament laws show that at the time of the adoption of the Second Amendment, legislatures had the authority to use status as a basis for disarmament. Moreover, those laws demonstrate that legislative disarmament did not always turn on a particularized finding of a propensity for violence. Instead, legislatures could disarm classes of people that they perceived as dangerous without any judicial scrutiny of the empirical basis for that perception. So they're literally arguing that the government can deem you dangerous or even just perceive you that way for whatever frivolous reason and strip you of your rights without any evidence or due process. And then they basically told him that if you don't like it, well, go get Congress to change the law and carve out an exception to your case. In response, Zherka released a press release titled "Lie to Your Bank and Lose Your Gun Rights," says U.S. Court of Appeals. In it, he points out that he did his time, paid his fines and restitution to the banks, and still is not allowed his rights. He also claimed that his former newspaper is the real reason that they went after him. Now, we have no way of knowing this, though there is some evidence of it. For example, the courts subpoenaed the mailing company he used for his paper, and there was evidence that he was targeted for a tax investigation in response to Tea Party activities. He had several lawsuits against New York and federal agents for this, while some prosecutors were big mad over a front-page article that he published calling them unethical and corrupt. So who knows? But one thing he said is true for sure, that this decision opens the door for the government to strip any American of their rights, not for violence or harm, but for allegedly lying, even on something like a credit card application. Zherka said that he plans to take his case all the way up to the Supreme Court, which will be interesting, as they've declined a number of nonviolent felon cases recently, as well as a bunch of Second Amendment cases in general. Alright, ladies and gentlemen, that is it for this video. You guys know the drill. For all of the algorithm things, please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.